Welcome to Talk Trials.
It is good to be back in the saddle.
I have to say, I am absolutely ready for this one. We cover a lot of legal battles on this show, criminal cases, civil disputes, corporate malfeasance. But today, we are not just looking at a lawsuit.
No.
We are looking at the lawsuit, the mobile patent trial of the century, the clash of the absolute titans.
It really was the heavyweight championship of the tech world.
In the red corner, we have the house that Steve Jobs built, the design perfectionists, Apple Inc. And in the blue corner, the rising challenger from South Korea, the manufacturing giant Samsung Electronics.
This wasn't just some legal skirmish. It was a defining moment for the entire industry. I mean, the shockwaves from this are still being felt today.
The stakes here were just astronomical. We were talking about over $1 billion in damages on the line. But honestly, it felt like even more than the money. It was about the future of how every single smartphone in your pocket looks, feels, and behaves.
Exactly.
It was a courtroom drama that basically defined the year 2012 in the tech industry.
You're right. It isn't just about the money. Although $1 billion is certainly nothing to sneeze at. This trial, Apple v. Samsung, filed in the Northern District of California, was really a battle over the soul of innovation versus the mechanics of competition.
Yeah.
It forces us to ask that really uncomfortable question.
Yeah.
Where does inspiration end and, theft begin?
That is the question. And our mission today is to dissect this landmark trial piece by piece. We are going to strip it down to the studs.
Let's do it.
We're going to look at the specific charges, the bounce backs and the black rectangles that everyone was arguing about. We're going to analyze the 3D chess that was jury selection, which honestly deserves its own deep dive.
That jury selection process is a psychological thriller all on its own. It really is.
We'll look at the smoking gun emails, and oh boy, were there smoking guns. We'll look at the defense's hold still arguments, and finally, that earth-shattering verdict.
And of course, we have to wrap it up with our 10th chair segment,
where we try to figure out if justice was actually served in the end.
But let's start where all good stories start. The context. You need the backstory here.
Okay, let's unpack this. The year is 2011. Set the scene for us. What does the mobile world look like?
The landscape of mobile technology in 2011 is shifting violently. You have to remember, just a few years prior, the world was dominated by BlackBerry, Nokia, phones with physical keyboards, tiny non-touch screens.
I remember my BlackBerry clicking away on that little keyboard.
Right. Then Apple released the iPhone in 2007, and it just changed the paradigm completely. By 2011, Apple is on a crusade.
A crusade? That sounds intense.
It was intense. Steve Jobs famously threatened to go to thermonuclear war on Android.
Yeah.
Apple is on the offensive to essentially drive Android devices off the market. They view Google's operating system, which Samsung uses, not just as competition, but as a stolen product.
Stolen product. So in their mind, this isn't competition, it's grand larceny.
They see it as an existential threat to the iPhone's identity. And that's a key point.
And Samsung isn't just some small player in this ecosystem. They're not some minor company.
No. And that's the key. Samsung is rising as the main competitor. They're releasing the Galaxy line of phones, the Galaxy S, the Galaxy Tab. And Apple looks at these devices sitting on a shelf next to an iPhone, and they say, hey, wait a minute.
That looks familiar.
That looks like ours. That works like ours. That feels like ours.
It wasn't just a vague similarity where you squint and maybe see it. Apple felt it was a carbon copy. So on April 15th, 2011, Apple pulls the trigger. They sue Samsung in San Jose, California.
The heart of Silicon Valley.
And the accusations basically fall into three main buckets, or pillars, as you called them.
Correct. And breaking down these pillars is crucial because this is exactly what the jury had to stare at for weeks on end. This wasn't just, did they copy? It was specific technical claims.
So let's start with pillar number one, utility patents. This is the how it works part of the phone.
Right. Utility patents cover the invention itself, the functionality, the software, the mechanics, not the pretty design, but the actual guts of the user experience. Yeah. And there were three big ones at the center of this case. First, and probably the most famous, is the 381 patent.
The famous bounce back.
Exactly. Now, to understand why this matters, you have to think about the user experience before the iPhone. Think about when you're scrolling through a list on your phone, maybe your contacts or a web page, you flick your finger and the list scrolls. But what happens when you get to the very bottom?
In the old days, on old computers or PDAs, it would just stop, like hitting a brick wall. It was rigid. It was ugly.
Right. It was jarring. The 381 patent covers a specific behavior where when you reach the edge of the content, the screen doesn't just stop, it pulls up slightly to reveal a background, showing you empty space, almost like stretching a rubber band,
Ah, I can picture it perfectly.
and then bounces back into place when you let go.
It makes the digital screen feel like a physical object with mass and elasticity. It's a very satisfying feeling, actually.
Precisely. And that feel is what Apple argued was a specific patented invention. It wasn't just an animation, it was a user interface cue used to communicate to the user that you have reached the end of the list.
So it solves a problem. How do I know I'm at the bottom?
It was an elegant, inventive solution, and Apple said, that's ours.
Okay, so that's the bounce. Then we have the 915 patent. This is pinch to zoom, right? Or is it more complicated?
It's often called that, but it's actually a bit more nuanced than just pinching. The 915 patent is about the logic the phone uses to distinguish between scrolling with one finger and scaling with two fingers.
Wait, so the patent isn't on the gesture itself, but on the computer deciding which gesture is happening.
In a way, yes. It's about the underlying code structure, the heuristics, that tells the processor, okay, I see one touch point moving, that means translate the page or scroll. Now I see two touch points moving relative to each other, that means scale or zoom. It's a seamless transition between those two states that Apple claimed to own. It prevents the phone from getting confused when you put two fingers down.
That's a critical distinction. It's not about the motion, it's about the brain behind the motion. And the third utility patent.
The 163 patent, which is tap to zoom.
This is a lifesaver. This is when you're reading a website on a tiny screen and the text is microscopic, so you double tap the column.
And the phone automatically calculates the width of that specific column of text, centers it, and zooms it to fit the width of the screen perfectly.
Without you having to fiddle with it.
Exactly. It makes the text readable instantly without you having to manually pinch and adjust. Apple argued this was a specific solution to the problem of reading full desktop-style web pages on small handheld devices.
Okay, so that's the how it works. Then we get to pillar 2, design patents, and this is where it gets really controversial. This is how it looks.
This is where it gets really visual and honestly where a lot of the public controversy came from. Apple asserted patents like D677, D087, and D305.
And unlike utility patents, these aren't about code or function.
No, these are about the ornamental design of the object. We are talking about the black rectangle with rounded corners.
A black rectangle with rounded corners. I remember people laughing about this at the time. Can you really patent a ship? It sounds absurd.
That was the billion-dollar question, and Apple's argument was it wasn't just a rectangle, it was their rectangle. They patented the specific radius of the corners, they patented the bezel, the black border around the screen.
Okay.
They patented the edge-to-edge glass look. They even patented the grid layout of icons on the screen rows of colorful squares with rounded corners on a black background.
So they are claiming ownership of the minimalist aesthetic, the entire look.
Yes. They argued that the iPhone's specific look was unique and non-functional, meaning it didn't have to look that way to work. A phone could be a triangle, it could have sharp corners, it could have buttons all over the front. Because the iPhone didn't have to look that way, the design was a choice, an artistic choice, and therefore it was a protected design.
And finally, pillar 3, trade dress. This is the vibe.
Vibe is actually a great word for it. Trade dress is a legal term that refers to the total image of the product. The packaging, the screen layout, the icons, the overall look and feel.
So this is about branding, not just a single design element, but the whole experience.
It's about brand confusion. Apple alleged that Samsung copied the Vibe so closely that it caused dilution of Apple's famous brand.
What's dilution?
The argument is, if you saw a Samsung phone lying on a table from 5 feet away, you'd think it was an iPhone. And if you think it's an iPhone, but it's actually a Samsung, that dilutes the uniqueness of Apple's identity. It cheapens the brand because now looking like an iPhone isn't special anymore.
So Apple comes out swinging. You copied our tech, our look, and our vibe. What does Samsung say? Do they just roll over and write a check?
Absolutely not. They launch a massive counteroffensive.
Yeah.
First, the standard defense, denial. They argue Apple's patents are invalid.
Invalid how? On what grounds?
Prior art. This is a huge concept in patent law. Samsung argued, we didn't steal it, and even if we did, you didn't invent it. They claimed that things like rounded corners, touch screens, and grid layouts existed in other devices long before the iPhone.
Like what?
Like the LG Prada phone, or even designs from the 90s, some tablet concepts. They tried to show the jury a history of design that led to the modern smartphone.
So if it already existed, Apple can't patent it. The patent office made a mistake.
Exactly. If it's obvious or not novel, the patent shouldn't exist. But then Samsung takes it a step further. They countersue.
I know you are, but what am I strategy? The old switcheroo.
Essentially, Samsung says, actually, Apple, you're infringing on our patents, specifically related to 3G and UMTS technology. These are the underlying communication standards that make a phone work as a phone.
Ah, this is the standard essential patents argument. Can you break that down for us? It sounds complicated.
Sure. So for the entire world to have mobile phones that talk to each other, everyone has to agree on a standard like 3G. Companies like Samsung, Nokia, Qualcomm, they all contribute their patented technology to create that standard.
So it's a group project.
It's a group project.
Yeah.
And because it's a standard everyone has to use, they are obligated to license those patents to everyone, including competitors on FRAND terms.
FRAND. What does that stand for?
Fair, reasonable, and non-discriminatory. Samsung claimed Apple was using their 3G tech without paying fairly.
And what was Apple's response to that?
Apple argued, sure, we use it, but you are obligated to license it to us fairly. Instead, you're trying to use these patents to block the iPhone from being sold. Apple claimed Samsung was breaching that FRAND obligation by turning a standard into a weapon.
So we have a standoff. Apple says you stole our design. Samsung says you're using our technology to make calls. It's total war, and it all lands in the lap of Judge Lucy Koh.
Judge Koh is a crucial character here. She runs a tight ship in the Northern District of California. And when you look at the proceedings, you can just feel her frustration.
You can tell she does not want this case to go to a jury.
She tried repeatedly to get these two companies to settle. She basically told them, look, going to a jury is a gamble. You're rolling the dice. She warned them that complex patent cases are unpredictable. Jurors are not patent experts.
She dragged the CEOs Tim Cook from Apple and the leadership from Samsung into settlement conferences. She basically locked them in a room.
But neither side blinked. Apple wanted blood, and Samsung wanted vindication. They both felt they were in the right.
So no deal. We go to voir dire jury selection, and this, my friend, is where the game of 3D chess begins.
It's just fascinating to watch the lawyers work here.
I love reading jury selection transcripts. It's really the only time normal people get to talk in court. And Judge Koh is really trying to weed out the biased people. She asked about strong feelings.
And in Silicon Valley, in 2011, everyone has strong feelings about Apple and Google. It's like a religion. Apple's the hometown hero in Cupertino. Google is the local giant in Mountain View.
It's like trying to find a jury for a Yankees versus Red Sox game in the Bronx. You're going to find bias everywhere.
Exactly. And you saw that immediately.
There was this one prospective juror, Mr. Tripiano. This exchange was absolute gold. He straight up told the court that he couldn't be fair.
It's fascinating. He didn't just say, I like Apple. He analyzed the case. He compared it to the old Apple versus Microsoft battles from the 80s and 90s.
Right. He essentially said, look, Apple had a nice operating system back then. Microsoft replicated it. Microsoft won, and Apple almost died. This is the exact same thing all over again.
He called the outcome before the trial started. He said, in my mind, this doesn't hold any water. And when the judge asked if he could set that aside, he said, my sense of justice might override your instructions.
My sense of justice might override your instructions. That is a bold thing to say to a federal judge.
You have to appreciate the honesty, though. Most people just try to get out of jury duty by saying they're busy. He engaged with the philosophy of the case. He was excused for cause, obviously.
Obvious.
But it shows the atmosphere. People already had a narrative in their heads. They saw Apple as the innovator and everyone else as the copier.
Then there was the Google employee, Mr. Okamoto. Apple tried to kick him out because, well, he works for Google, and Google makes Android, which is what Samsung uses.
It seems obvious, right? Conflict of interest. The guy's paycheck is signed by the company that makes the software Samsung is using.
But the judge initially let him stay.
She did. It shows how high the bar is to remove a juror for cause. Just working in the industry isn't always enough. You have to prove actual bias, or that his employment would be directly affected by the verdict. Eventually, he was removed, but it took some doing.
But the most important person in that jury pool, the man who would end up shaping the entire verdict, was Velvin Hogan.
Velvin Hogan. Now, this is a name that becomes very controversial later. At this stage, he's just a prospective juror. During questioning, Judge Koh asked the pool a standard question. Has anyone here been involved in lawsuits in the last 10 years?
A standard, simple question.
And Hogan didn't raise his hand.
He didn't.
He stayed silent. Even though, as it turned out later, he had filed for bankruptcy in 1993, and that bankruptcy involved litigation with Seagate Technology.
Seagate. The hard drive company, why does that matter?
Because Samsung had a massive strategic investment relationship with Seagate. A huge portion of Seagate was owned by Samsung. It was a major business partnership.
Oh, wow. So you have a guy who was sued by a company that Samsung is deeply involved with. He doesn't mention it.
Not a word. And when he was asked about his background, he described himself as just a user of technology. He owns hard drives. He uses computers. He didn't position himself as a legal expert. Yet.
Keep a pin in that yet.
Exactly.
Yeah.
Because that transformation from average user in the jury box to legal expert in the jury room is the pivot point of this whole story.
One thing the transcripts highlight, which we often forget when watching the movie version of this in our heads, is the boredom factor.
Yeah.
We talk about this being a high-stakes drama, but for the jury, it was days and days of technical specs.
There were media reports of jurors struggling to stay awake, literally nodding off in the jury box.
You're kidding.
No. Judge Koh even offered them coffee and authorized standing breaks so they could stretch their legs and get the blood flowing.
Okay.
It's a stark contrast. On one hand, you have lawyers billing thousands of dollars an hour arguing for $1 billion.
And on the other?
On the other, you have normal people, a bike shop manager, a social worker, trying to understand the source code for a hold still routine without falling asleep.
It's a lot to ask of anyone. So the jury is finally picked. Let's move to the trial itself. Apple's case. The offensive. Apple had to prove that Samsung didn't just stumble upon these designs, but that they had a deliberate crisis of design.
This was Apple's strongest narrative thread. They didn't just rely on the patents, they relied on Samsung's own words. They introduced a document that became legendary in legal circles, the Relative Evaluation Report from March 2010.
Smoking gun.
Essentially, it was a 132-page internal Samsung document comparing their Galaxy S1 to the iPhone. And it was brutal. It was a self-takedown. It went feature by feature, comparing the two phones. And in almost every category, the iPhone won.
So they basically did Apple's work for them.
They did, and it gets worse. There's a quote from the Samsung executive saying the difference between their user experience and the iPhone was like heaven and earth.
Heaven and earth. That's not subtle.
Just think about that. When a jury sees the defendant's own executive saying, our product is terrible compared to theirs, the difference is heaven and earth, we need to make it like theirs, that's devastating.
It implies intent. It's not accidental convergence, it's a directive. Fix this by being like them.
Exactly. Apple painted a picture of a company in panic mode. They argued Samsung realized the iPhone was killing them, so they abandoned their own distinct designs and decided to copy Apple to survive.
To back this up, Apple brought in the experts. Let's talk about Dr. Ravin Balakrishnan. He was the guy for the 381 bounce back patent.
Right. Balakrishnan was there to bridge the gap between the code and the visual. He analyzed 21 different Samsung devices. He testified that the Samsung Gallery application used the bounce back feature exactly as claimed in the patent.
And he didn't just say it, he showed it. He had to show it to the jury.
Visual evidence is key in a jury trial. He showed videos, he'd scroll to the bottom of a photo album on a Samsung phone, and boing, it bounces. He overlaid that with the iPhone animation. The jury could see it with their own eyes. It wasn't abstract code, it was the behavior on the screen.
You can't argue with what you see right in front of you.
It's very hard to. Then you had Dr. Karan Singh on the 915 or 163 patents, pinch to zoom and tap to zoom.
What was his approach?
Singh's testimony was very methodical. He broke down the heuristics. He used video evidence to show the tap to zoom. He demonstrated that on 24 different Samsung products, if you double tapped a block of text, it expanded to fill the screen just like an iPhone.
He's showing that the behavior is identical.
And that the software rules deciding, is this a scroll or a zoom, were virtually identical to Apple's logic.
And on the design side, they brought in a legend, Susan Kare.
The graphic designer who created the original Mac icons, the Happy Mac, the trash can.
Yeah.
She is royalty in design circles. Bringing her in was a flex.
It adds a certain weight to their argument.
Absolutely. She testified that the Samsung icons were knockoffs. She put up a grid of Apple's colorful, rounded square icons next to Samsung's.
And side by side.
To a layperson, side by side, they looked remarkably similar. The green phone icon, the gear settings icon. She argued that Samsung mimicked the color, the shape, and the metaphor. She said it was too close to be a coincidence.
And Christopher Stringer, an Apple designer, testified about the painstaking process Apple went through. Why was that important? What does that testimony add?
He was trying to establish value. He described sitting around a kitchen table, iterating hundreds of models, scrapping thousands of ideas. He humanized the design process.
So it's not just a rectangle, it's the product of immense effort.
He was trying to establish that this design wasn't accidental. It was the result of thousands of hours of genius work. If it's that hard to create, it's valuable. And if it's valuable, stealing it costs a lot of money.
So Apple paints this picture. We worked hard, we created something magical, Samsung panicked, called their product Earth compared to our heaven and copied us. Now Samsung gets their turn, the counterpunch.
Samsung's defense was tricky. They couldn't win on the vibe because, frankly, the phones looked similar, so they had to win on the specs. They had to get technical.
Get into the weeds.
Deep into the weeds. Their key defense on the 381 bounce-back patent was the hold-still routine.
Hold still. Explain that.
Okay, so the 381 patent claim is very specific. It requires a translation, a movement beyond the edge, and then a bounce back. Samsung argued, our phones don't do that. When you hit the bottom, they stop, or they glow blue at the edge.
The blue glow defense. I like that name.
Exactly. They argued that a hard stop or a visual glow is fundamentally different from a mechanical bounce. The code executes a different command. It says, hold position and show blue, not move past edge and return.
It's a very fine distinction. Did Apple's expert agree?
In cross-examination, this was a key moment. Apple's expert, Balakrishnan, actually admitted that a hold-still behavior, if that's all it did, would not infringe Claim 19 of the patent.
It feels like a big admission, a huge point for Samsung.
It was. Samsung seized on that. They argued this exonerated devices like the Galaxy Ace. They said, look, the code is different, the behavior is different, their own expert agrees, the patent doesn't apply.
They also attacked the validity of the patents. They argued prior art again.
Right. They brought out the F700 designs and other earlier concepts. They tried to show the jury that things like rounded corners and centered zooming were natural evolutions of technology, not unique Apple inventions.
So they're saying everyone was moving in this direction anyway.
Exactly. You can't patent the rectangle just because it's pretty. They tried to dismantle the idea that Apple was the sole inventor of the smartphone form factor.
And then came the damages rebuttal. This is where it gets into the weeds of accounting.
Michael Wagner, Samsung's expert, criticized Apple's numbers. Apple was asking for total profits from the phones. Wagner argued, wait a minute, people buy phones for the battery, the screen, the Android OS, the camera.
Not just the bounce back.
They don't buy it just for the rounded corners. He was arguing for apportionment. You should only get the profit attributable to the patent, not the whole phone.
That makes sense.
It's a very logical argument. He tried to bring the number down from billions to millions.
But the most memorable moment of the defense case, maybe for the wrong reasons, was the altruistic witness, Dr. Tim Williams.
Oh, this was a disaster for Samsung, a masterclass in how not to testify. It was a train wreck.
Set the scene. What happened?
Dr. Williams was testifying about Samsung's 3G patents. He was there to support Samsung's counterclaim, to show that their patents were valid and valuable. And on the stand, he tried to play the role of the noble academic.
Okay.
He claimed he wasn't doing it for the money. He said, and I quote, he was testifying to support a strong U.S. patent system for his children.
For the children, in a billion-dollar corporate lawsuit, you can't be serious.
That's almost comical. It sounds like a bad movie script. The jury must have just rolled their eyes. And then, on cross-examination, Apple's lawyer asks the inevitable question, how much are you getting paid for this noble act, doctor?
Yeah.
She has to admit, it's about $1 million a year.
Oof. I'm doing it for the kids.
Oh.
And the $1 million. That has to hurt your credibility with the jury.
It shatters it. It just completely undermines everything he said. It makes the defense look disingenuous. It reinforces the idea that Samsung is just throwing money at the problem to make it go away. It made the jury feel like they were being played.
So after all that drama, both sides rest. Judge Koh reads the jury instructions. And folks, if you think listening to a podcast is long, try listening to 109 pages of legal instructions being read out loud.
It was grueling.
Yeah.
And the verdict form, it was a nightmare. It wasn't just guilty or not guilty. It was a grid, a spreadsheet.
A spreadsheet.
They had to answer yes or no for dozens of devices across multiple patents. Did the Galaxy S infringe 381? Yes, no. Did the Galaxy Tab infringe D889? Yes, no. Hundreds of individual questions.
You'd think that would take weeks to deliberate. You have to go through the evidence for every single phone and every single patent.
It should have taken weeks. A thorough examination would require looking at the claim charts for every single cell on that grid. But the jury came back in less than 3 days.
Less than 3 days. 22 hours of deliberation, I think it was. That is fast.
Suspiciously fast for that volume of work. It suggests they found a shortcut.
August 24, 2012. The verdict is in. The courtroom is packed.
And it was a landslide. Apple wins big. The jury awarded approximately $1.049 billion.
$5 billion with a B. That number sent shockwaves through the industry.
And not only that, they found the infringement was willful.
That's the dagger. What does that mean legally?
Willful means they knew they were infringing and did it anyway. In patent law, if infringement is willful, the judge has the power to triple the damages. So that billion could have become $3 billion. It was a complete repudiation of Samsung's defense.
Let's look at the specifics. The 381 bounce back.
Infringed by almost all devices. The jury didn't buy the blue glow defense. They saw the bounce and said guilty.
915 pinch to zoom.
Infringed.
163 tap to zoom.
Infringed. Total sweep on the utility patents.
The design patents.
The rectangle.
D677, D087, D305. All infringed. The jury decided that Samsung did indeed copy the black rectangle. But there was one exception, and it's kind of funny. The D89 patent regarding the iPad design.
Yes. In a small twist, the jury found Samsung did not infringe the iPad design patent with their Galaxy Tab 10.1.
This echoes the ruling in the UK, right, where the judge famously said the Samsung Galaxy Tab was not as cool as the iPad, so it wouldn't be confused.
Essentially, yes. U.S. jury agreed. They basically said, this tablet isn't distinct enough or cool enough to be confused with an iPad. It was a small victory for Samsung amidst a sea of defeat. A little bit of, it's not infringement because it's not good enough.
A backhanded compliment, if I've ever heard one.
Yeah.
And Samsung's counterclaims, their 3G patents, the ones Dr. Williams was testifying for the children about.
$0. The jury awarded them absolutely nothing, a complete shutout. They found either Apple did not infringe or that Samsung's patents were invalid or exhausted.
Wow. So the trial ends, Apple victory laps, Samsung vows to appeal, but then the foreman factor starts to leak out. This is where it gets really strange.
This is where the story takes a turn into legal drama territory. Velvin Hogan, the foreman, he starts doing a media tour.
He starts giving interviews to major news outlets. And what he says raises a lot of eyebrows in the legal community.
He told the press that he led the jury through the invalidity analysis, which is fine, a foreman leads. But he explained how he did it. He talked about his own experience with patents, something he hadn't really disclosed.
He brought outside knowledge in. Isn't that like the #1 rule you can't break as a juror?
It is. Specifically, he used a legal argument about interchangeability of software and processors. He told the other jurors that because the software on a prior invention couldn't be placed into the processor of Samsung's phones, the prior art didn't count.
Wait, was that in the jury instructions from Judge Koh?
No, that was the problem. That was Hogan's own home-brewed legal theory. He was applying a technical standard that the judge never gave them. He was effectively saying, listen to me, I know about this stuff, leading the jury away from the court's instructions.
So he became an expert witness in the jury room.
Samsung jumped on this immediately. They argued this was jury misconduct.
As they should.
Right. Jurors are supposed to decide based only on what is presented in court. If a juror brings in outside evidence or erroneous legal theories and presents them as fact to the other jurors, that's a huge problem. Hogan was basically testifying in the deliberation room where Samsung's lawyers couldn't cross-examine him.
And Hogan also admitted something about the damages, right? Something that sounded personal.
He admitted he wanted the damages to be painful.
Painful. That's a loaded word.
It suggests a punitive intent. But here's the thing. Punitive damages are for the judge to decide, not the jury. The jury is supposed to calculate compensation. How much money did Apple lose? Not how much should we punish Samsung. If they inflated the number to punish Samsung, they broke the rules.
And then the Seagate thing came back up, the lawsuit he didn't mention.
Post-trial, Samsung's investigators, who are obviously digging into everything, found out about Hogan's bankruptcy and the Seagate lawsuit.
And just to remind everyone, Samsung had a strategic relationship with Seagate.
Exactly. Samsung argued this was deliberate dishonesty. They said he wanted to get on that jury to punish Samsung because of his bad blood with their partner, Seagate. They argued he was a stealth juror who lied to get in the room and swing the verdict.
It's a mess. Samsung moved for judgment as a matter of law, citing inconsistencies. Like, the Galaxy Ace was found not to infringe the 915 patent, but other phones with the exact same software were found to infringe. How does that even happen?
That inconsistency supports the theory that the jury was rushing. They might have been looking at the vibe or the heaven and earth memo rather than the specific claim charts for every single phone. They checked yes for one phone and no for another, even if the software was identical. It shows they weren't being precise. They were sending a message.
Which brings us to our favorite part of the show, the 10th chair.
The 10th chair.
This is where we sit down figuratively with the jury and give our assessment of what just happened.
And just a quick disclaimer. What follows is our commentary for informational and discussion purposes only. We are not lawyers, and this is not legal advice. We are just two people looking at the facts and trying to make sense of it.
So looking back at all of this, the patents, the memos, the foreman was justice served?
It's the billion-dollar question, isn't it?
Yeah.
Let's look at the boredom factor again. Do we think the jury actually understood the difference between a hold-still routine and a bounce-back routine at a code level?
Honestly, I doubt it. I think they glazed over. I think the technical details washed over them, and they were left with the big, simple story.
I think it's highly likely. When you have highly technical arguments about heuristics versus code libraries, and then on the other side you have a clear emotional narrative, heaven and earth, crisis of design, they stole our genius, the narrative usually wins.
The speed of the verdict suggests that too. Less than 3 days for $1 billion multi-patent, multi-device case. They couldn't have possibly gone through every single element of every single claim for every single phone.
Mathematically, it's almost impossible if you do it right. They likely glossed over the technical invalidity arguments. They looked at the crisis of design emails and said, guilty, next. That feels like the most plausible explanation.
Those emails were devastating, though. You can't ignore them. Even if the patent technicalities were complex, the intent was clear. Samsung said, in their own words, we are behind. We need to be like Apple.
Exactly. The jury got the big picture right regarding Samsung's strategy. Samsung did pivot to copy the iPhone. That is undeniable from the documents. They saw the iPhone, they panicked, and they changed their designs to match. The evidence for that is overwhelming.
There's a big but coming. I can feel it.
But the specific damages calculation and the patent-by-patent analysis were likely flawed. They were rushed. And the influence of the foreman is deeply, deeply troubling.
Velvin Hogan.
If you have a foreman who is introducing his own home-brewed legal theories about processors and software, and he has a potential undisclosed bias against a partner of the defendant, that taints the process. It turns the jury room into something it shouldn't be. It's no longer a deliberation based on evidence.
It feels like rough justice.
That's the perfect term. Rough justice. Directionally correct regarding the copy. Samsung did copy. But procedurally messy regarding the specific patents and damages.
It's like they got the right answer to the math problem, but they showed the wrong work.
And used a calculator they weren't supposed to have. The verdict feels emotionally correct based on the evidence of copying, but legally and procedurally, it's full of holes.
So what does this all mean for us? For the people buying the phones today?
Well, in the short term, it meant that for a while, everyone was terrified of looking like Apple. It solidified the rectangle with a screen as the dominant form factor, but it also forced competitors to be very careful about the vibe. It's why you see more variation now in how Android skins look, for instance.
And it made Apple $1 billion richer. Well, on paper, at least until the appeals started.
That's a whole other deep dive. The damages were eventually whittled down significantly in years of appeals and retrials, but the moral victory stood. The label of copier stuck to Samsung for a long, long time.
Before we go, here is a final provocative thought for you to chew on.
We rely on the jury system to be the bedrock of justice. Peers deciding the fate of peers. It works for robbery, for contracts, for negligence. But if a single foreman can sway $1 billion verdict with his own home-brewed legal theories that weren't in the judge's instructions, is the jury system actually capable of handling complex technology patent wars?
Or are we asking 12 random people, a bike shop manager, a teacher, a retiree, to solve a puzzle they don't have the pieces for?
Are we asking them to perform brain surgery with a hammer?
That's a powerful way to put it.
Precisely. Maybe some disputes are just too technical for the reasonable man standard. Maybe we need a different way to solve these kinds of fights, like a specialized tech court.
Something to think about the next time you pinch to zoom on your phone.
Indeed.
Thanks for listening to Talk Trials.
See you next time.
See you in court.